As Michael said, my name is Hannah Bergman. I'm an attorney at the National Archives, and I answer lots of records questions on a day-to-day basis. So part of my job is to look at general record schedules. Part of it is to work on the Capstone policy. Part of it is to just field questions from agency counsels and advise on records management issues. I also do a whole host of other things like ethics regulations and financial disclosure forms, EEO cases, et cetera. So we have a pretty small staff at the archives, and all of our contact information is available on archives.gov, on the General Counsel's webpage. There are only 9 attorneys, so we all will take questions. If any of you have sort of burning records management legal questions, feel free to give us a call. I think I get a lot of calls because I'm at the beginning of the alphabet, and right? Which is completely fine. So I'm going to start with just a couple of points that aren't really in the slides, but relate to those questions that I get from agency counsel that deal with records management issues, and I just think are sort of hot button issues. The first thing is what it means when something comes to the archives, or we sent it to the archives. A lot of people think that if they sent it to the archives, then it went into a black box and we're just going to take it from there. There are many reasons why things might come to the archives. The 2 key reasons, one is that it's a temporary record and it's in a federal record center, and you, the agency, is our customer and you're paying us for storage. We are just your warehouse. So in those situations, you have legal custody of the records. Come on in, sorry, I just started. You're not, oh, that's entirely reasonable. I also get lost in this building all the time. So what I was saying is there are 2 reasons why records might come to the archives. One, that they're temporary records. They're being stored in a federal record center on the agency's behalf, and you're paying us for that storage. So when that happens, the agency has legal custody of the records, and you are responsible for processing FOIA requests, discovery, and congressional inquiries. You ask for those records back by contacting your records officer. It's as simple as that. We charge you for that, but you still have legal custody of that. Once records are accessioned into the holdings of the National Archives of the United States, which is the legal body of permanent records that exists here in this building, out in College Park, and in places throughout the country, those are the permanent archival records. And at that point, we take over responsibility for access requests. And we provide, generally, access to the public of those records sort of outside of the FOIA process. You just come in, you walk into a research room, you say, I want to have access to alien records from people who immigrated in the 1920s. And we say, great, here's a cart full of those records. And you get access to them. When you have litigation as an agency, as some of you may have experienced personally, and it involves accessioned records that we at the National Archives have legal custody of, you have to come into our research rooms like any other member of the public and ask for those records 1 cart at a time on the pull times, which are roughly 4 times a day. So the reason that we have such long transfer periods for permanent records, 15 to 30 years, is because it's a pretty onerous process to go through the public records request process to get at those records. So we don't want to take in legal custody of records that have an active business purpose in your agencies. If you have active litigation on them, they're not appropriate to come to us. You should keep them within your agency's control and be able to get at those yourself. So that's why the transfer time is so long, the 15 to 30 year time frame. In addition, the National Archives typically does not apply the same restrictions on records that you might apply at an agency. We do not apply FOIA B5 to records in our legal custody. If you are uncomfortable with public access to your records, you should keep them until you are more comfortable with that. We do apply some level of screening for the other FOIA exemptions, but in general, our goal is to make records available to the public, and we're going to screen differently than you would at your agencies. So that is something that comes into the calculus of when it's appropriate to transfer records to us. And that's another area where I think counsel can interact with records officers to have a robust discussion about what's happening with those records, if they're being used in active litigation or not. We also, on very rare occasions, will receive a version of a litigation hold from the Justice Department for accessioned records. We do not like these. We are coming to terms with the fact that we will take them. So it is possible, particularly in environmental lawsuits or in tribal trust matters, where accessioned records that are part of our legal holdings are relevant to litigation that is happening in the present day. If you have one of those matters and you need us to implement a litigation hold on those records that are in our legal custody, you should work with DOJ, with the Discovery Council. So whether that be Allison Stanton or Sarah Himmelhoch, thank you, exactly. To get those letters, DOJ has a particular type of letter that it will send us when accessioned records are at play. And it essentially says, we know that you're the archives and you don't destroy records, but just in case you were thinking about destroying these, please don't. And so then we'll take some steps to sort of flag them in the holdings management system as do not deaccession, basically. In addition, if we were processing those records to weed out what we consider non-record or temporary records, things that were commingled in your permanent accession that shouldn't have come to us, and there's a litigation hold in place, we will send them back to you rather than destroy them. So that's another purpose of the litigation hold on archival records. We strongly discourage you from accessioning records subject to active litigation, though, because of all these sort of problems, and we don't want to really deal with that. The other thing that we do is pre-accession electronic permanent records. We do this on a limited basis, so it's possible that you might have permanently valuable electronic records that you can't keep in your agency's custody because of in your agency's physical custody because of technological concerns. So some of the Iraq War records are an example of how we've pre-accessioned them. So we have electronic records here at the archives that we have physical custody of, that we're maintaining, but DoD hasn't signed over legal custody to us. And we're DoD is still responsible for FOIA access, et cetera, but ultimately they will sign over access and we'll make them available to the public. That's not a common situation, but it is available in the rare instances where it's appropriate. All right, so that's my spiel on what it means when it's at the archives. We often get FOIA requests for things that are in fact not at the archives, so that's why this comes up a lot. And then, I did just want to point out, we're going to go through the statute. So all of NARA's statutes are 44 USC, and then we have Chapter 21, 29, and 33. Those are the ones that would primarily apply to you guys. There's a whole host of different laws that apply to presidential records. The White House, the Executive Office of the President, subject to the Presidential Records Act, they don't throw things away, ever, under any circumstances. Though they do have the legal authority to, they essentially just don't. Because it's an onerous process to figure out what they could dispose of. And so, as a consequence, all White House emails come to the National Archives, period. And then they go to a presidential library. So I'm going to start going through the statutory changes. We're going to go over Capstone and email management. If you have questions, just interrupt me, raise your hand. We'll get a microphone to you. All right. Oh, and I got that pointer clicker. All right. So for the first time since 1950. You got a question? Oh, yeah.
Yes, I was wondering if NARA learned anything, say, regarding those of us in the room who may have joined the federal service prior to the year 2000, and all of our records were destroyed in the fire. Has anything been learned from that so that this would not repeat itself?
The 1976 fire at the National Personnel Records Center, that fire?
Well, yes, I thought it was. I thought it was less than the year 2000. I didn't know it was that old, but.
Yeah, is that 77? 74. Okay, so there was a fire in the mid-70s. the 6th floor of the National Personnel Record Center burned off. Then we took the floor off and put a roof on, and then that building existed for 40 years. So in terms of what happened there was a massive effort to recover all of the affected records. Those were military records, service records, obviously very important to the veterans to prove their service. So we've done several things to sort of reconstruct those records so that everyone can get their benefits. And we have obviously in place now a whole host of regulations about fire safety in buildings that store records. For example, you cannot have a space heater here, no matter how cold you are. But there are also at 36 CFR, I think it's in the 1270s, are the regulations on essentially humidity controls, water sprinklers, et cetera, all those things that you have to have in place at a building that stores permanent records. So not only do we comply with our own regulations, but also Iron Mountain, who many of you may use to store records. I'm sure there are other vendors out there that store records. They're just the most common competitor to us. Everyone complies with those building standards in an effort to prevent that from ever happening again. It's a really interesting and sad story, and we still don't know what caused the fire, to my knowledge. So, all right. So I'm going to move on to the Federal Records Act amendments that happened in November. This is the first time the Federal Records Act and the Presidential Records Act were amended since 1950. This is a pretty big deal for us. It had been a long time in coming, and the archives was very involved in sort of getting these amendments through and proposing them over time. So we're very pleased to have updates to the Federal Records Act for this century. So, yeah. Right. So a summary of the major updates. It changes the definition of federal record. We'll get to that shortly. It specifically covers electronic records so that we're not focused on machine readable, which had been the old terminology. It grants the archivist determination as to what's a record and what's not. It authorizes early permanent transfer of records for the pre-accessioning that I talked about. It clarifies responsibility for federal employees when they use non-federal email. We'll have a whole 5 slides on that. And then it does some other things, specifically related to the executive order on presidential records and sort of review of privileges. Again, that's not going to apply to anyone who doesn't work at the White House. So that is in fact the section 2. And this essentially codifies what is now the current executive order on president's review of privileged materials. There have been a back and forth over a couple administrations on sort of who was allowed to assert a privilege on behalf of the president. Was it just the incumbent president? Was it the former presidents? Was it the representatives, et cetera? This is now all codified, so it's not going to change by executive order anymore. Authorizes pre-accessioning of electronic records. This is what I was just talking about. Allows us to take in those records. It's something that we have been doing for many years, but it makes it clear that we have the statutory authority to do that, which as agencies, it should assure you that we are in fact only taking physical custody, that legal control of those records resides with all of the agencies. So whatever your access determinations are the ones that will prevail, not ours. It does also modernize 3106 with regard to unauthorized removal and destruction of records. And so here you'll see in italics just places where the regulations interpret the statute and will be updated. I think that we're hoping to have a package of updated regulations out in the Federal Register as proposed rules maybe by June or so. So they're circulating about in track changes. They'll eventually get to the policy office in about 30 days, and then we'll get to the Federal Register from that. As the agency who publishes the Federal Register, we still lack control over when things get put in the Federal Register. This is the disclosure requirement. Section 10, it establishes requirements for Federal Records Act employees who use personal email. There's a similar provision for records that are subject to the Presidential Records Act. All right, so we've got the modernization of the definition again of federal records. So there we'll be updating our regulations as well at 36 CFR 1220 and 1222. So these are places where you can look if you are trying to do some analysis as to what constitutes a record or a non-record or what the appropriate agency management responsibilities are. These are all things that are fairly detailed and laid out in our regs. Also, you have unauthorized removal of classified records. We refer to this as the Sandy Berger provision. As you may know, Sandy Berger put records in his pants and stole them. But we got them back, and Congress has now made it clear that people who steal things should not have access to the original records. We have already, several years ago, changed our procedures and put in security measures so that this would not happen. But the updates to the Federal Records Act sort of basically solved problems that have accumulated over the past 20 years, 30 years or so. This section is entirely housekeeping, so there had been a commission that existed, again, 40 years ago. That was removed from our statute. One of the things that Congress is doing now, all committees are doing on their own accord, is changing all pronouns so that they're gender neutral, which I think is really great. Just FYI, if your statute's getting updated, that'll be happening. All right, so the new definition of records says, this is 44 U.S.C. 3301, all recorded information, regardless of form or characteristics, made or received by a federal agency under federal law or in connection with the transaction of public business and appropriate for preservation by that agency, blah, blah, blah. So the key change here from the big block of text that Aaron had at the beginning is elimination of the term machine readable and the insertion of regardless of form or characteristic. So it's really just an attempt to make it more modern. And then recorded information is further defined. All traditional forms of records, regardless of physical form or characteristics, including information created or manipulated, communicated, or stored in a digital or electronic format. And then here we have our quintessential definitions of non-records. So duplicate copies of records and library and museum material. Books also part of this definition. One thing that I would stress is that you should not spend a lot of time, if you can avoid it. There may be litigation-related reasons why it's useful to do so. But on a day-to-day basis, when you're trying to manage records or you're trying to provide advice about agency management, don't stress over whether or not it's a record or non-record. Just accept that it's probably a record. The definition is broad enough that sort of from a practical management purpose, assume it's a record. It could be a transitory record. It could be a temporary, which is a form of a temporary record, or it could be a permanent record. Not all records have to be kept forever. So it's okay if it's a record. If you are trying to spend enormous amounts of time splitting hairs over whether or not it's non-record, that should be a conversation and energy reserved for a minority of situations where there's a specific legal strategy in mind related to a case where it's really important for you to argue that it's non-record because of the statutory framework you're under. For example, in the EPA litigation over the administrator's text messages, which is I think CEI v. EPA, there's a lot of argument that those are non-record materials. That's quite logical, quite plausible, is part of a litigation strategy. And those text messages about, meet me, at Starbucks so we can prep for a meeting, arguably not a record, something that they can certainly rely on as part of that strategy. But again, on a day-to-day basis, when you're trying to make big policy decisions about sort of where your agency is going, spending a lot of time trying to parse out non-record from record is not worth the time. Accept that it's a record and sort of go from there. if you need help with this, we would be happy to determine it's a record for you. So Aaron said that this provision didn't actually stem from an event. It didn't stem from any recent events, that's true. It stems from a problem that Henry Kissinger created when he left the State Department. So in the late 70s, early 80s, Kissinger was Secretary of State. He took with him his personal papers, the Secretary of State's personal papers, and he said these are non-record copies. All of the record copies are in the State Department's official central file system. We said, no, that's not true. The Office of Legal Counsel at the Justice Department said, it's up to the agency to determine whether or not those are federal records, and Kissinger, in consultation with State Department counsel, determined that they weren't federal records. This provision fixes that problem, which has largely not come up since. But this is why Henry Kissinger's papers are at the Library of Congress and not at the National Archives. And this is sort of the genesis of that statutory change. We do not anticipate intervening on agencies' decisions on a daily basis as to whether or not something's a non-record or a record. But I think that we would certainly use this provision were the Henry Kissinger problem to reassert itself today. If that gives you a little bit of context for what happened. All right, electronic messaging accounts. So I'm actually, so this is part of the amendments. This amendment obviously passed in November, was in the works long before any shenanigans regarding Secretary Clinton's email came to light. This is something that had been a concern of our oversight committees for many years. There were many other agencies where this had arisen. This was a problem, I think, during the Bush White House years with regard to PRA employees using I'm totally blanking on the Republican Party's email services rather than the White House ones, right, to do business. So long time in the works, not related to Clinton, though clearly on point. So federal employees may use non-official electronic messaging accounts, but when they do so, they have to forward or copy that message to the official account within 20 days. Intentional violations of this rule will be a basis for disciplinary action. Yeah.
So I've done some counseling, since
Mm-hmm.
it came out.
Oh, right, sorry.
Hi, I've done some counseling on this since it came out, for
Mm-hmm.
people in the agency, making them aware of it. One question that I have is, what is the intersection with this forwarding provision and transitory records?
Yes.
If, for example, somebody is saying on their personal email, hey, I'm going to be late for a meeting, are they then obligated to forward that in so that they may delete it following this law?
No, they are not. So one point on this slide, and then we'll move on to answering that question and the next slide. Intentional violation shall be a basis for disciplinary action. We at the archives are not going to be providing advice on what an intentional violation is and what disciplinary action should be happening. That is something that you should work with your personnel offices and use your own penalty guide to determine that. I think from our standpoint, one could always discipline employees for doing the wrong thing, such as destroying federal records. The statute makes that clear, but this isn't really a new thing, right? You could always be disciplined for disobeying agency policy. So work with your own human capital folks. We have nothing grandiose to say about this in terms of guidance. The definition of electronic message and the question about transitory. All right, so first, electronic message is more than email. This is intentional. Congress is very clear that they did not mean to limit this provision to email. Or if they did mean to do so in November, they certainly no longer mean that it be limited to email at this point in time. So it's going to apply to text messages, chats, and other yet to be invented forms of communication. If your agency, I don't know, I'm Snapchat is, I think, a version of transitory. So whatever the case is, electronic message is much broader than email. All right, so the question about transitory. Transitory records, per our regulations, have a value basically of less than 180 days. So outside of the electronic messaging construct, anything that you need to keep for less than 180 days is by definition transitory, and you can just deal with it in the system in which it resides. You don't need to take any additional electronic records management steps to dispose of it. And it's, what is your business need for that information? So if you just need to know, how, where the exits are in a building, how to get to the coffee, whatever, where the soda machine is, very basic stuff, right? That's a transitory record. You're not going to need the directions on how to get to this room after today's meeting, right? You can go ahead and dispose of that under the general record schedule in our regs. Now, if you have communicated information in a personal account that is transitory, I think our current thinking is that if the value of the record is less than 20 days, then the statutory requirement doesn't apply. Does that make sense? Yes. So it's going to be 1236.22C. I just reviewed these yesterday. So 36 CFR 1222, 1220, yeah. 1236.22C will be updated in the next batch that we send to the Federal Register. It's sort of the most heavy lift, and that's the statutory changes are sort of what's driving those reg updates. Like I said, I'm thinking June-ish for that publication. There will then be a new .23 paragraph that applies the 20-day rule to other electronic messages that are not email, and that specifically says records that have a value of less than 20 days, this rule does not apply to. So I can also say that that was our thinking as of 5 o'clock yesterday. So in drafting regulations, obviously lots of things change. It's possible that that could change. It's possible that we would get public comment that would lead us to change the final guidance. But definitely be on the lookout for that. It is certainly our plan to address these issues in that reg update. A place where we publish these things, if reading the Federal Register just isn't part of your day-to-day process, is the Records Express blog, which is on archives.gov. And it's the blog of our National Records Management Program. So those are the folks that organize this class. They process the record schedules, they do reg updates, et cetera. So that blog is a good place to look for high-level guidance coming out of NARA, bulletins, that sort of thing. You can subscribe to an RSS feed or email updates if that's helpful. All right. Any other questions about electronic messages, electronic messaging accounts? All right. So the President's Records Management Directive is the current sort of overarching guidance that has come out of the White House. The first time since Harry Truman that records management has gotten the attention of a sitting president, which is pretty exciting. And it set forth several goals for agencies. These are the high-level goals. Require electronic record keeping to ensure transparency, efficiency, and accountability, and then to demonstrate compliance with federal records management statutes and regulations. These should be happening regardless of what the president says, right? But this is the high-level guidance goals of the President's Records Management Directive. Those have been implemented in a joint memo from the archivist and OMB, which is M1416. And this came out following IRS and EPA troubles with email, and sort of reiterated what our current guidance is on email management. So I encourage you to look at the latest M-1416 for our latest thinking on email management that is in conjunction with OMB. So it's not just us who care about these things. So the way in which agencies are going to meet these two goals, which are, so the goals are to manage all email electronically by the end of 2016, and to manage permanent electronic records that are created electronically by 2019, is via the Capstone approach. So Aaron mentioned this earlier, and NARA has a lot of guidance on what we mean by the Capstone approach, but just to reiterate, we have a fancy picture, and it's a way to manage your email based on the role of the account holder, and so you're making broad decisions about the person themselves and their job and what it is they're doing, rather than making decisions based on the content of each individual email message. So under our old scheme of regulations, every time you send an email, you're supposed to look at it, like, this email is about ethics advice. Obviously, I file it under the file series and the file plan related to ethics advice that our agency has established and is in conjunction with the general record schedule. And so I'm going to put a file code in that, and it's in our office, 1102B, I think, is the file code, and it has a 6-year disposition. And every time I send an email giving ethics advice that says, oh, you can keep that gift, no, you can't keep that gift, please finish your financial disclosure form, no, really, please finish your financial disclosure form, no, you actually need to list the underlying assets in your financial disclosure form, all of those things I should print and file and put in a folder with a 6-year disposition. So that was not happening. I was not doing that. Every other federal employee also not doing that. So what we've come up with is the Capstone approach to records management, which takes the individual determination about the content of the email out of the equation, right? So that you're just making broad categorical determinations based on what the person's job is and whether or not they're creating permanent records. So as Aaron said, we all copy our bosses when we have serious problems with important things. Theoretically, the top tier of the agency, the capstone of the agency, would be where those permanent records would reside. So when I'm offering legal advice related to the interpretation of our statutes, that's precedent that another agency is going to rely on, related to the 20-day rule and what's a transitory record, for example, I'm going to copy my boss, the general counsel, and that email is going to be captured and managed as a permanent record because his email account is permanent. Does this make sense to everyone? We all, because I feel like I say this a lot, but then I get these questions that make me think that I'm saying entirely the wrong thing, and it's not sinking in. So is this sinking in? Are we okay? All right. We have actually finally put out in the Federal Register for public comment a general record schedule for how you can implement this at your agency. So it just went out for public comment on April 1st, I believe. So there's a 60-day comment period, basically. During this time, we're also going to have a public meeting. So if you really care about email records management, you can come to the archives on May 21st and talk about these things in depth. We're going to get feedback from the public interest community about these decisions. Our efforts to have a public meeting are a direct result of email management being such a hot button issue. Not only, obviously, has Secretary Clinton's use of the personal email account been a problem, the IRS and the EPA issues, we also had a lot of public controversy about the CIA email record schedule. So people care about these things. It's quite apparent to us that this is an area where the public interest community is really engaged, which is why we're going to have this public meeting. So the Capstone General Record Schedule puts all employees into 3 categories: permanent, 7-year, and 3-year. This is a list of the permanent categories. These people, so this is in the Federal Register on April 1st. You can go to the Federal Register. You can also go to the Records Express blog for all of the background on this, if you cannot squint and read the fine print here. This is a list of 9 categories of people whose email would be per se permanent. We've got the head of the agency, assistants to that head of the agency, deputies of those people, staff assistants to those people, Principal management positions such as the chief operating officer, the CIO, the chief knowledge officer. That's a new thing. OMB is probably making you have one. Chief technology officer, CFO, and their equivalents. Directors of significant program offices. This is where agencies have a lot of wiggle room. What is a significant program office is an agency-specific question that you should certainly spend some time thinking about. Principal regional officials, such as regional administrators. Roles or positions that routinely provide advice and oversight to the agency, such as your general counsel, your chief of staff, your inspector general, et cetera. And then anyone else who hasn't been captured that has a presidential appointment with a Senate confirmation. These people create permanent email. That is what the schedule says. Yeah. Should we go through the temporary email slide first, or you want to ask your question? Okay. No, I was context, right? So the temporary bucket is the 3 and the 7-year bucket. The 7-year bucket is by far the largest of any of these. The vast majority of employees should fall into the 7-year retention category. The 3-year category is meant for the individuals who make the really important work of government happen, the logistical processing of things, Social Security benefits, payroll, people who work in the mailroom, people who are couriers for agencies, right? The day-to-day operations of an agency that are really important to the delivery of services, but those people just they aren't creating agency policy, they're not creating documents that affect the rights and interests of citizens, et cetera. So that category is the 3-year one. Everyone else is in the 7-year category. Aaron's in the 7-year category, I'm in the 7-year category, Michael's in the 7-year category. These are people who do important work, but whose email we're going to assume should be kept for 7 years. Now, agencies have discretion to keep all of this email longer. So the 7-year rule is a floor. So if my boss says, what I really want is all the attorneys in my office, I want to keep their email for 15 years. The Capstone GRS allows for that without any sort of, they allow for the agency to make that determination, right? And that could just affect your attorneys in the general counsel's office and not affect management and program analysts, in your strategy office, for example, right? Okay, what was your question?
I can speak up.
Oh, just for the video folks.
Our agency has problems getting permanent appointments.
Mm-hmm.
Makes some news sometimes. What about folks who frequently hold acting positions?
Right.
Well, yeah.
Yeah, so I don't have, it's not super easy to pull up the GRS in front of me, but the GRS itself does address that. And if I recall correctly, the frequently asked questions document, which is like 30 pages at this point, it specifically has an FAQ on acting, first of all. I think that we said if you're in an acting position for 60 days, then this is triggered, right? So there's the notion that you're acting because someone's on maternity leave and that person's coming back and you're keeping the trains running on time, but you're not changing the direction of the agency, right? Or there's the notion that you have a hard time getting people confirmed, and so when you're acting, you're really in charge. And so we wanted to give agencies the discretion to make that determination and recognize those two realities. So another rule that the 60-day requirement attaches to is if you're in an acting position that requires an OGE 278 financial disclosure form, that's triggered with the 60-day rule, I believe. So we're trying to look at other areas of the law that had an acting sort of component and when other statutory requirements are triggered. And so the public financial disclosure requirement is triggered at that time. So I think we were trying to tie it to that, if that helps. So in addition to the schedule, what we published and what's available on the Records Express blog is a white paper that explains to a regular lay person who is not steeped in records management law what's happening here. And then a frequently asked questions document that goes through questions like acting, et cetera. That actually reminds me, I'm going to go back to, because there's one thing I wanted to cover on the electronic messaging slide. and it relates to email as well. First, contractors. Contractors who have agency accounts. Think that we have essentially thought that the rule is going to, so the statute is specific to federal employees with this 20-day rule. So legislative branch employees, not covered by it. Probably still a good idea to follow, because I think that you'd have a sort of hard time articulating why you, GPO employee, didn't follow this rule merely because it's specific to executive branch employees. Let's see. So the other 2 points I wanted to make were FACA committee members. If you have FACA committees, you should think about how this affects your SGE employees or representatives to the committee, right? So are these people employees? Do they have agency email accounts, et cetera? There is a GRS that deals with FACA records specifically, and our FAQs on that, which have just been updated in consultation with the Secretary Management Office at GSA, which has FACA oversight responsibilities, essentially say that, you know, if the person does not have an agency email account and they're going to use their personal account, then to deal with all of the record keeping issues that attach to that, not just this, what you should do is just copy the DFO, the designated federal official, on your record emails. Does that help people who have FACA committees? This is something that's come up as an area where there's been a lot of questions. And so also contractors not going to be covered by this requirement just because of the statutory language, but I think we would say contractors in the Capstone paradigm, you know, are probably going to sort of by default be captured, because you're going to have accounts that are given to contractors that are agency email accounts, you know, and they're going to fall into one of the temporary buckets, basically. Right. Questions about that? Did that make sense? All right. All right. Oh, yeah.
I think I'm missing the big picture of what the Capstone project is. So,
I'm sorry. We can go back. Yes.
so does that mean I have a choice to do either or can you do a? Let's say that you know, I manage contracts and we have a 2-year requirement. I'm making it up. I'm choosing something less than 7 years.
Okay.
And I'm a 7-year employee. Does that mean I have the choice of, if I don't want to sort through my stuff, I can just keep it 7 years? But if I do want to, like I've closed out a big contract, it's mucking up my hard drive and I want to delete it, and I can, I get to delete it.
Right. This is an area where the agency policies that Erin talked about are really important. So how a Capstone approach to email management fits with your other records management programs is a matter of an agency discretion and policy. So yes, if what you want to do and what you're able to do is manage those records, those email records by the content, and say, well, this was a 2-year record, this contract is closed out, this matter is closed, Capstone allows for that. It also allows for instances where Erin creates permanent records related to appraisal dossiers. And so she's in a 7-year category, but she has an obligation to take those permanent records and do something else with them, put them in the appraisal dossier so they're preserved. What Capstone is meant to be is just a blanket approach that sort of allows you to make these broad-based determinations with an acceptable level of risk, right? So the worst that happens is that you kept the 2-year record for 7 years. Yeah, that's not so great, but what we all know is that there are these blobs of email out there that agencies aren't disposing of because they don't feel like people are doing that. They're not going through it and filing their email according to a schedule, and they can't say, oh, well, we're disposing of this in accordance with a regular schedule, right? So Capstone provides that sort of schedule and basis for disposition without requiring you to go through and make those individual determinations. Now, the consequence of that is that it's entirely possible that you're a 7-year employee and you have 10-year records. So we're okay with that. We're okay with those being disposed of at the 7-year mark. We've come to terms with accepting that risk in this policy. If you're okay with that, that's up to you. The Capstone memo that we put out essentially gives agencies that discretion to say, well, if an employee has 10-year records but they're in the 7-year bucket, the employee has an affirmative obligation to manage those 10-year records for 10 years. Or, no, we're just going to manage all of the email for 7 years, and that's the decision we're going to make. You can make either of those choices. The policy gives you that discretion. Does that make sense? Question over there? Yeah. Oh, that was a poor choice.
I just want to add really quickly that agencies can submit their own email schedules as long as they are meeting the obligations of the Presidential Records Management Guidance. We do have several agencies who have submitted their own record schedules for email, the most famous, infamous of which is the CIA one, pending. NARA decided we had our own record schedule for email that we had put up, and then we decided the GRS was going to more or less be in line with all of those decisions. So that schedule was actually withdrawn from the Federal Register and the approval process, and we are waiting as an agency to employ the GRS once it's finalized. So there are levels of choices here that can be individualized, as Hannah said.
Yeah. Okay. Do we have any other questions? Did I get the big picture there? So we have a lot of resources on Capstone available. If you're dealing with these questions or you want to grapple with it more, just let us know. All right. So discovery, obviously, this matters for agents of counsel, because it's your job. So these are sort of the areas I think that we deal with access requests, whether they be discovery, congressional request, FOIA, or spoliation claims. I think the important thing to take away is obviously that what we're talking about in terms of non-record, it's useful in your litigation context. It's useful in FOIA, but FOIA has a different definition of what's an agency record. It's broader than under the Federal Records Act, right? Congressional requests are not bounded by such notions of recordness, right? They just exist. So if you have something, you're going to need to find it and make it available. And obviously in discovery, you're bound by the federal rules of civil procedure. And record schedules, as Aaron had said, really guide what you should be looking for in a discovery context and what you're likely to find and what can be disposed of, what you're going to put litigation holds on. But they're not the be-all, end-all. So areas beyond email that you should think about in e-discovery issues, we've sort of gone through all of these in our conversations earlier. Text files, calendars, PowerPoint, spreadsheets, sort of all of the things on your drives, the unstructured data, your structured data as well, intranets, so whatever's in your home agency communications. I don't know if your agencies have something that's sort of akin to like a Facebook internally, but that's something that we have at the National Archives and is an area that would certainly be subject to discovery, FOIA, et cetera. So don't forget about those strange repositories that are creeping up now in this sort of age of social media. Likewise, there's a lot of employment litigation on availability of things like Facebook pages, Twitter, Instagram, that sort of stuff, as it relates to disciplinary proceedings against employees, right? So if your employee says they're sick and they're posting on their Facebook that they're really at the beach, that Facebook evidence can come into play. How that happens, be aware of and be cognizant. I would just, in the 20 minutes we have left, probably not an area that we want to delve deep into, but certainly there's a burgeoning area of personnel law related to that. Keep in mind the Privacy Act is also going to affect your ability to retrieve that information. Data on mobile devices, I think, is a huge issue. So think about how you're managing your data on your mobile devices. Are you allowing employees to bring their own devices? Have you learned the important lesson of the dangers of that happening? and what sort of are your policies for letting employees who telework keep information on laptops? Are you giving them the laptop, from the agency to use, or are you requiring that telework eligible employees provide their own computer? That can really change what your policies need to look like from a records management standpoint, from a discovery standpoint, from an IT security standpoint. I think we've recently had instances where employees in the telework context have had things on their personal computer that they should not have had on their personal computer, and they no longer have those personal computers. So you must address this issue. You do not want to have to be in a position where you're asking an employee to give their computer over so that their hard drive can be wiped and that they will no longer have the cute pictures of their children that they have not backed up anywhere because you need that computer. I really encourage agencies to give people devices. I think bring your own device is really dangerous from my standpoint. All right. Oh, did I go the wrong direction? Okay, no. Okay. We've covered all of these, right? Do people still have backup tapes? Yes. I feel like backup tapes, they're like paper at the archives. Eventually they'll stop being acceptable, but for the interim. All right, so we've just got a couple of slides on foundational sort of discovery issues. Obviously, Arthur Anderson, a key Supreme Court case on how document retention policies are going to interact with your litigation obligations. That's the place we start from. Obviously, what Aaron has spent a long time talking about is the notion that you can, in fact, dispose of things in accordance with those document retention policies if you have them. So the entire process of scheduling your records is really to allow you to dispose of the records in a way that is defensible in litigation, is defensible from a budgetary aspect, that you're just not keeping everything forever. So as Aaron said, your file plan is something that you're going to want to look to anytime you have a discovery demand, and where your file plan or your record schedules are deficient and the records are not yet scheduled, they have to be maintained until they're scheduled. And so scheduling does take a long time. I'm quite aware of that, right? Like it is gonna, even if you submitted a schedule to us tomorrow and it was perfect, it's gonna take probably a year for that schedule to go forward. So you need to plan in advance for being able to manage the large volume of material that you're collecting, particularly in an electronic environment. There are a lot of storage costs associated with that. There are a lot of retrieval costs associated with it. But unscheduled records can't be deleted from a records management standpoint, and deletion of those records has serious consequences in litigation because you have no document retention policy to fall back on as a defensible mechanism. So obviously these rules apply not just to paper, but to electronic records. I think we're sort of in a place now where we don't have to make, hopefully, those distinctions as often. But I did want to talk about the Gerlich case a little bit. Is anyone familiar with the Gerlich case? It's about 5 years old. So the Justice Department had been recruiting honors attorneys at the end of the Bush administration. And there was a process to vet those applicants that essentially led to people looking at Facebook pages to determine things like political party affiliation and other not good things. So that they were making determinations about your application based on your political beliefs and your hobbies, what clubs you belong to, et cetera. So this case sort of focuses on the catch-22 of, well, once you've done the illegal activity, are you obligated to keep a record of your illegal activity, or can you destroy that evidence? And if you destroy that evidence, how is that going to work out for you in the litigation about your ongoing misconduct? So it's a really they're very interesting opinions. The district court found for the Justice Department, the circuit court ultimately overturned that decision, and then eventually the case was settled out of court once the circuit court made it clear that justice was probably not going to be able to defend its actions. So, as you can see here, Gerlich focuses on this, the notion that once you've created these records, you did have an obligation to preserve them, that the Federal Records Act creates this affirmative obligation to keep what were, in this case, printouts from applicants' Facebook pages with annotations on them about whether or not they were good to go or not based on their political party affiliation and other sort of life choices. So the court here, I think, relies on Talavera, which is a much more fulsome discussion and sort of the case that preceded Gerlich, and talks about the interaction between EEO regulations that require an agency to retain records versus the record schedule and where the two intersect. The ultimate takeaway from this is that you've got to be aware of situations where there are regulations that intersect with your record schedules, along with statutes of limitations, and how long you're keeping things. In the Gerlich case, essentially the circuit court said the plaintiffs are entitled to a spoliation inference because they can't prove their case because the Justice Department destroyed these records. They should have known that these records were going to be needed in this litigation. There was an OIG investigation. There was a lot of press attention. These records were really going to be instrumental in whether or not the plaintiffs were allowed to prove their case or not. And so, absent the records, the spoliation inference was against justice. There's also some fascinating aspects of the Privacy Act that come into play in the Gerlich case. Gerlich talks about, so the Privacy Act has this notion that an agency isn't allowed to collect information about an individual's exercise of First Amendment activities absent consent of that individual or a legitimate law enforcement need. Vetting you for a job application is not a legitimate law enforcement need. So did you have consent? This is an area where you might want to sort of pay attention to what's happening in personnel offices, in how you're vetting applicants internally. I think we all know in this, sort of Google environment, social media world, of course your instinct is to type in the person's name to Google to see what's happening before they show up to the interview. As federal employees, you shouldn't be doing that. Gerlich talks about that as a real problem. If your human capital office isn't aware of this, if they haven't provided guidance on it to your selecting officials, to the interview panels, or if they're not getting consent from the applicant to do that, right? Another way to solve this problem is that you require consent of all applicants to do some basic Googling of them. That's an area where I think counsel can be proactive and don't not end up in the same position as DOJ. It was an important lesson we can all learn from. The DOJ, the payout, was substantial. The settlement agreement is public. I think it was more than $100,000 that Justice ended up paying to these applicants. So another case that I just wanted to mention, I don't know how many of you interact with the criminal side of the world, but in the event that you're involved in OIG work or work for a criminal agency, there's obviously an obligation with regard to litigation holds for evidentiary materials that's going to come into play. This is a case out of New Jersey where, as it says there, the FBI failed to preserve really important text messages on an agent's phone, and then the consequence of that was that the defendants were not convicted. So there's an obligation when you issue a litigation hold for that litigation hold to extend to things like text messages on agents' phones when those are going to be used in the litigation prosecution. Lots of people run out of space and delete their messages. This is what happened, I think, in that case. So if you don't have adequate storage, that's an area where you really need to think about what your record-keeping requirements are. and provide for the policies related to forwarding those text messages to email accounts, et cetera, so that you're not in that position. No one wants a defendant to go free just because you deleted the text messages. So I also just wanted to touch on updates to Rule 37E, the Federal Rules of Civil Procedure. This is the current rule, which says, absent exceptional circumstances, a court may not impose sanctions under the rules for failing to provide lost ESI as a result of routine good faith operation of an electronic information system. So if you've done all the right things, but for some reason you do not have the emails, Rule 37 provided this out for you, still does, but probably by next year, I understand, these updates will go into effect. So there have been a long time in the works, updates to the Rules of Civil Procedure. I think Justice has been fairly involved in crafting Rule 37 and are making their opinions pretty vocal on sort of the pros and cons of these changes, but the rule is going to be changing. I'm thinking December-ish 2015 is when that's most likely to happen. But it will say, failure to preserve electronically stored information. If electronically stored information that should have been preserved in anticipation or conduct of litigation is lost because the party failed to take reasonable steps to preserve it and cannot be restored or replaced through additional discovery, the court can essentially order the spoliation inference or sanctions. So keep that in mind. Those updates are coming. A lot of the things that were encapsulated in the good faith notion are still there in the advisory notes to that rule. That's the link if you want to get the full report. Another thing that I wanted to touch on with regards to spoliation inferences in litigation and claims that records no longer exist is this notion of unauthorized destruction report. So there's a statutory obligation for an agency to report to NARA when you have a unauthorized destruction of records. So if you are in the middle of FOIA litigation and you realize that you've destroyed the records and you shouldn't have, that's an unauthorized destruction. You need to send us a letter. 36 CFR 1230 has the requirements. Typically what's happening is a letter from the agency records officer to the chief records officer of the United States, which is Aaron's boss, Paul Wester. 1 to 2 pages, summarizes the incident. We will then reply and say, we'd like more information about this. Are you going to make sure it doesn't happen again? You will then make sure it doesn't happen again and assert in writing to us that that's what's going to happen. If you want to see how this is currently playing out, essentially the State Department, sent us such a letter. We sent then a report back. I think all of that's about to be released or was released this morning or is in the process of being released. Something with that is happening. But unauthorized destruction of records reports often do get press attention, in part because they come about in litigation, so there's already sort of a public interest in what's happening. But we do expect to see them even in the mundane instances where there is no press attention, no agency head is involved, et cetera. Make an unauthorized destruction report, talk to your records officer about that, make sure that you're doing that, and then make sure you actually follow through and you really do make whatever policy changes or management changes are necessary to make sure this doesn't happen again. Like the IRS, another example of unauthorized destruction reports. All right, so now we have a couple of slides about email management. This sort of repeats what we have said before earlier this morning, where we said there are a lot of ways in which you can manage email. Not all of them are super useful from a records management standpoint, but you're probably using them in litigation. So just be aware of what your email archiving tools are. And it's possible that with a Capstone approach to email management, you could use those litigation tools to implement your records management policies if you do it correctly. So this references something called DoD 5015.2. Those are certified records management applications, which are really fancy ways to manage records in accordance with our regulations. NARA previously, maybe like a decade ago, endorsed this standard as like the gold-plated way to do electronic records management. We have since realized that no one can afford gold-plated electronic records management systems, not even DoD. So we've backed off from that endorsement to say that that's one of many ways in which you can meet our obligations, but there are all these other ways as well. So if someone comes to you and says, but the system is not 5015.2 compliant, it is okay. You do not need to buy a 5015.2 compliant system. In fact, if you did buy one, it's probably making you frustrated on a daily basis because you can't get records out for litigation or manipulate them or do things with them. So they're not as exciting as we thought that they were in the early 2000s, late 90s. I'm going to skip over that one and move on to backup tapes to say that backup tapes are covered by the General Records Schedule. We have recently updated the schedule that covers these, so we've gone from GRS 24 to the new, revised, better, user-friendly Excel spreadsheet version of the GRS 3.2, item 40 and 41, which essentially say that you can destroy backup tapes and recycle them in accordance with your regular processes. They are also not an effective means of managing your records. So if someone says to you, I'm keeping my records on the backup tapes. No, you are not. They still need to be held, though. If you have them, litigation holds are often going to reach backup tapes. Do not forget about them. You cannot assume they no longer exist, even if they don't exist. For some of your systems, they probably exist for other ones. These two cases are about what happens when attorneys agree to things that they don't understand. So the Fannie Mae case, essentially, the attorneys there said, oh, we can meet that deadline and produce that ESI. And they could not, and they received sanctions for that. In the Knickerbocker versus Corinthian College case, that's sort of a little more interesting read. It's a more recent case. It goes into what happens when people try and parse the language of a court order a little too closely and say things like, backup servers, those aren't the same things as backup tapes. I didn't know that you meant the backup server too. No, you did, right? So this is sort of a wariness of don't read the court orders too narrowly, don't interpret the discovery request too narrowly. It's not good faith to say, well, you said tapes, how was I to know you also meant servers? In that case, the attorneys also failed to tell employees to actually implement the litigation hold, which is another real problem. So just you knowing that you should delete the records isn't enough. You have to actually tell people that there's a litigation hold in place. If you're in a cloud-hosted environment, you should think about how you will implement your litigation holds in that environment. That is largely affected by what your contract with the cloud provider looks like. So be sure to take a look at those contracts, figure out if you can get the information out on demand, what time frame you're looking at for a turnaround for massive exports of that data, what format it would look like, if this is even possible, where the data resides, is it outside of the US? Are there other implications to that? Is your data commingled with other entities? Is it possible for them to segregate out what you need and leave the rest and just give you your information? Is it likely the cloud provider would be subpoenaed and you would not know about it and your data would be implicated? What's going to happen there? So these are all issues that a good contract and a good structure can deal with, but keep them in mind. I'm sure they've probably been raised to you before by reviewing contracts for IT systems, for records management issues and other IT management issues is an important part of, I think, how counsels can provide useful advice in the records arena. All right, so a couple of more points. Metadata, that's a thing, you should be aware of it. So for email, we have specific regs on what constitutes the metadata of an email. That was widely litigated in the Armstrong cases. The most important thing that I think systems now today may not be able to handle is the notion that distribution lists need to be exploded to have everyone's actual names, right? So if in your Capstone approach or your electronic records management system, your e-archive, whatever it is you're using, you have, in your agency, you have an email distribution list that is senior staff at agency.gov, and that then all of your senior management gets those emails. When you capture that information, either for litigation or for record-keeping purposes, you need to actually know who is on the senior staff. That is a crucial part of that record. Armstrong really talks about that as being a key difference between the electronic record and the paper printout of an email, and why the electronic record has additional added value. So think about how you're getting that recipient information, how you're exploiting those distribution lists, because that can really come into play poorly if you haven't thought it through. Format, obviously key. If you don't know it already, OMB has metadata guidance that requires you to use a particular schema for managing your metadata. It's the Common Core metadata standards. NARA is also working on metadata guidance that will hopefully not conflict with OMB's. Another sort of metadata guidance document that you should be aware of is if you're an agency that the Justice Department is going to be litigating on your behalf. DOJ's e-discovery folks have sort of a one-page handout of what data they're going to need when you give them records for litigation. All right. Capture everything in a preservation order. No, really, capture everything. More sort of details on that. These are just key takeaways are to always check the law. It's changing, particularly case law on e-discovery and burdens. The federal rules will be changing. We didn't talk about amendments to Rule 26, but those are in the works as well. So just be in the update. Don't rely on an outdated version of the rules, and sort of plan for those changes and differences in the burden analysis. Here are some handouts. Sedona Conference, always super useful for guidance if you haven't checked it out. This is Erin and I's contact info, and then it's noon, so I think we're done. We're here if you have questions, though. We're happy to talk about any issues you guys have.